Despotic power is always accompanied by corruption of morality. Greetings, one and all. Welcome to today's discussion organized by APNA, that is, Association for Parivartan of Nations, as a part of the Tribal Echoes, the first national virtual art, culture, and literature summit. A 3 days event from 8 to 10th June 2021 to commemorate the ideals and sacrifices of the folk hero Birsa Munda, an Indian tribal freedom fighter who led a tribal religious millenarian movement during British rule and sacrificed his entire life fighting for tribal rights. He died on 9th June 1900 while lodged at Ranchi jail under mysterious circumstances at the age of just 25. With this, I would like to introduce today's topic. Who will watch the Watchman? Birsa Munda's custodial death and a long history of police atrocities. Custodial deaths and police brutality is not something rare in India, but surely it is something rarely talked about. Every human has certain basic rights, but at times our hatred takes a toll over us and we forget that the person who has violated some law or has committed a crime is also a human being. And even after years of independence, what happened to Birsa Munda is still happening to 5 people in India every day, as reported by National Campaign Against Torture in 2019. To tackle this issue, we not only need stringent laws, but also mass awareness about its existence. So here we are with this session. Now, I'll take this opportunity to extend my heartfelt welcome to our learned speakers for today. Advocate Shailesh Poddar is a lawyer currently based out of Ranchi and practices criminal law. He has actively worked with civil societies like PUCL, Ranchi, and social work groups on issues of human rights violation, gender justice, and right to education. We also have with us Siddharth Lamba, a lawyer by profession who is currently a project officer with the Prison Reforms Program of the Commonwealth Human Rights Initiative. His work at CHRI involves research and policy advocacy and improving monitoring in prisons by strengthening the working of prison oversight bodies, such as Board of Visitors and Under Trial Review Committees. His work at CHRI also includes analyzing prison statistics and advocating for prison reforms with National Human Rights Commission and legal aid institutions. It is my pleasure to share this virtual platform with two such amazing advocates. Beginning with today's session, firstly, I would like our speakers to throw some light on the rights of people under police or judicial custody as granted by Article 22 of our Indian Constitution, and on the guidelines issued by the Supreme Court in the case of D.K. Basu versus State of West Bengal. Also, do you feel that issuing guidelines is enough to curb this extreme violation of human rights?
So, Shailesh, would you like to? Yeah.
Sure.
So I'll just state that under Article 22, basically there are two important points. One is that no one would be arrested without informing them of the grounds of arrest and by denying them the right to consult a lawyer of choice. And the second point is that the person who has been arrested has a right to be produced before the nearest magistrate within 24 hours of the arrest, and no one shall be detained beyond 24 hours of the arrest without the authority of a magistrate. Now, there are some exceptions to the second point for detention beyond 24 hours under preventive detention, under laws like PSA, where the preventive detention can go on for months. With regards to the first very basic right under Article 22, which is that no one would be arrested without informing them of the grounds of arrest and denying the right to consult a lawyer of choice, I would very briefly just mention one case law, because it shows the facts of the case showed that how the police can try to subvert this right by not directly violating it. In many cases, in the very recent case of Disha Ravi, also we saw that the police arrested the person from Bangalore and then produced the person in Delhi. In that case, also the lawyers of the defendant had raised this point, and in this very case of Uttarakhand Sangharsh Samiti versus State of UP, this point was raised, and the court had said that the accused at the pre-trial stage is not to be moved away so that he can be under a handicap, inhibition, or difficulties in consulting a lawyer of his choice. So basically, it has to be realized in essence that there should not be any arrest without mentioning the grounds, and there should be a lawyer of choice available. So these are the two, I think, the two major rights under Article 22. Shailesh may add more.
Yeah, no, yeah. So I think that in terms of law, I think we have a well-established law. We have Article 22 in the Constitution, first and clause first and second, as Siddharth rightly said, it provides a safeguard that any person arrested has to be brought before the magistrate within 24 hours. Secondly, the person has a right to legal counsel, legal aid. The third clause, though, it goes against the very idea of the first and two clause, but we are not on that topic. That's a completely different topic. So apart from the Article 20, apart from Article 22 also, in fact, CRPC Chapter 5 arrest, it provides certain safeguards. That 41 after DK Basu judgment 41 A, B, C, D came, then there are other provisions where it's the duty of the police officer who was arrested to take care of the health of the arrestee. So I think we have enough laws on paper which essentially safeguards the right of a person who's arrested and to protect him from a custodial torture. The problem is in execution. There are many loopholes, even if there are many loopholes, there are many apparent open secrets. It's everyone knows about it. The magistrate sitting on the bench, the High Court judge himself being a lawyer in most of the cases, having dealt with custodial torture cases, everyone knows what happens. Everyone knows how long, how much is the procedure followed. So despite having a very good law on papers and despite having several judgments, DK Basu was maybe the starting judgment. After that, we have numerous judgments. Arnesh Kumar, the last judgment that came, which specifically said that for offenses that are punishable up to 7 years of age, up to 7 years of imprisonment, there's a safeguard that you don't have to immediately arrest. It does not mean that if there's an offense that entitles a police officer to arrest, it doesn't mean that he has to go and arrest, which essentially means that even a police officer having an information about, let's say, a rape or a murder, even in those cases, it's not mandatory to arrest the accused unless the circumstances show. So I think in the terms of law, in the terms of Supreme Court judgments, starting from DK Basu to Arnesh Kumar and several other judgments, CRPC, Constitution, we have enough safeguards. The problem is in execution. It's seldom executed and seldom people are held accountable. I doubt that even one case of contempt has gone to the Supreme Court against Arnesh Kumar judge. Not even a single case has gone where the court has actually decided that, okay, this is the contempt of the order. And it specifically orders to the magistrate as well that it has to safeguard, that it does not mean that there need not be a mechanical remand, there need not be a mechanical arrest of a person. So I think the problem here that we will discuss majorly is about the execution of the laws and its implementation.
It is the lack of accountability that creates the problem. Even in the Arnesh Kumar judgment, we clearly find the direction that the Supreme Court said that if the magistrates do not fulfill their duty to check in the remand whether the checklist under Section 41, as Shailesh mentioned, have been furnished or not, and if the police fails in their duty to abide by the guidelines of Arnesh Kumar, there will be a departmental inquiry and departmental action. Yet, in reality, it is yet to be seen. So, accountability, implementation, and accountability are the two things which are missing and which keep these guidelines and these very good words just on paper and keep them away from the reality. Yes.
Yeah.
So, moving on to the next question. We know that we have model prison manuals, which lay down a number of rules regarding how a prisoner must be treated and what facilities should be provided. But from various reports, it is quite evident that these manuals are being ignored. Our audience would love to know any possible reasons for this.
So, regarding the model prison manual, the state of Jharkhand is yet to have its own manual, in fact. We are still following the Bihar prison manual that we adopted in 2000 when the state was forming. There have been discussion in Jharkhand to have a model prison manual. In 2015, I think during a writ petition, the court in fact even submitted that they have a draft in proposal which they are planning to implement, but it's been 6 years. There's no prison manual we have for Jharkhand. In fact, I filed an RTI recently, only last month I have a reply which they state that till date, the Jharkhand government haven't implemented its own prison manual. We're still following the Bihar prison manual, despite Bihar having its own manual. They revised their own manual in 2012, if I'm not wrong, on the lines of a model prison manual. So the importance of a prison manual comes in the fact that it gives you certain right. If in case it's not enforced, you can at least go to the court. You can at least make a grievance that, okay, this is the right that I've been granted and this is not being fulfilled. For example, I think recently it happened in the Rajasthan case that the prison manual prescribed that certain class of people have to do the menial job.
Yes.
Only when it came into light that finally the Rajasthan government, the High Court ordered and the provision is not being changed. So these are the benefits of having a prison manual. For example, many under trials, they don't know that in fact they have a right to have a home food, though it's a luxury that many cannot afford, but still, like there are many things about prison manual that is necessary. I think it's, for example, when we say that for example, when directions were made that in police stations people need to know what their rights are. Similarly, I think a model prison manual should be in the prisons for the under trials and the convicts to know what their rights are. It's something else they are implemented or not. That's the second fight. But the first fight is the information. And a prison manual is a very important piece of legislation. It's a very important act. It's the determining act for how the prisons function, starting from your food, your waking up timing, your sleeping timing, your barracks, with whom you are allowed to put, separation of prisoners, separation of under trial, separation of prisoner based on their age, medical conditions. So being such an important piece of act, I think it's very important for the states to implement it strongly, and along with an education, because most of the prisoners that go into the prison, they are hardly educated. So it's very important to have a prison manual in the local language, not just Hindi or English, in a local language, and it needs to be out there in a place where they can actually read and educate themselves about. So that's my take on prison manual.
I think I completely agree with what Shailesh said. And also, we should keep just one thing in mind, that the model prison manual is also not a panacea for all the ills that plague Indian prisons. Indeed, the problem is that many states, or I would say most of the states, have not amended their prison rules. These examples are very few where the prison rules have been amended after 2010, which, as Shailesh mentioned, it is Bihar. The latest one is in Odisha. Then there is Delhi, there is West Bengal, Rajasthan. But these are very few. Still, most of the prison rules are archaic, based on a system which was colonial. Even you will find some provisions in the model prison manual which are not very much informed. However, I completely agree with the point that it is still a step ahead. It is still a next step towards realizing better governance in prisons. The problem with MPM, the model prison manual, is that it is a recommendatory document, because it is made by the Ministry of Home Affairs, and the central government or the Ministry of Home Affairs does not have the power to govern prisons, as prisons are a state subject. But the state government should not should also keep this in mind, that they should not completely rely on model prison manual. For example, while working in Rajasthan, we found that there were some practices in Rajasthan with regards to the oversight bodies that they had made for seeing that under trial prisoners are not incarcerated for very long durations in prisons, which do not find mention anywhere in any other law or even in model prison manual. So there are state practices which can be termed as good practices. The larger point is that the prison rules should be amended where an amendment is due. So yeah.
Yes, sir. So the next question is, how can we improve police-community relations? Can community-oriented policing reduce the inherent conflict between the law enforcement and the service roles of the police?
I think the first step towards enhancing police community relationship is to build a relationship of mutual trust with the community with direct and frequent interactions. So what needs to be kept in mind is that it should not be a one-off event. So it should not be a single event for the purpose of press attention and all of that. But it should be a gradual process where trust building should be at the center. The aim should be to understand the local reasons, the local culture, which nurture a particular crime or which lead to a particular crime occurring in that area. The focus should also be on the fear perception towards the police. So the general public and mostly the marginalized identities, which can be intersectional, which definitely go beyond gender, religion, and caste, are very fearful of the police system and the working of police. So this needs to be focused. And one thing which I think very important is very important in the Indian context is that there is no formalization or institutionalization of this initiative in India to build a relationship between the community and the police. There are individual persons of IPS officers and from the state cadre also who are very proactive and they take individual initiatives. So when these persons leave from a particular place, they are transferred, the initiative falls back. Very few examples of institutionalization of this could be the all women police stations. So in a way, apart from other targets, all women police stations can also enhance community participation or bridge the gap between community and the policing. But there is a lot to be done. In Bangalore, there was another initiative which I found, that the beat constables were made intermediaries between the police station, the police institution, and the community. So these kind of initiatives need to be explored and they need to be institutionalized. Now it is the time that these should not just be pilot projects or isolated initiatives, but these need to be institutionalized by way of formal training and modules that are given to the police personnel. Yeah.
Yeah, I think regarding community policing, I think there's a lot of work that needs to be done in the Indian context. For example, I think Tamil Nadu's Friends of Police is that was started Friends of Police as a slightly similar concept of a community policing. But what it led to was that the people who were recruited as Friends of Police, they started exercising power in the terms that they had a card that designated them as Friends of Police. They had a close access to police officers. So it led to a lot of misuse of those powers. In fact, Gerard Bennick's case also, I think Rob was ordered against a few Friends of Police personals. And in fact, they discontinued the scheme after Gerard Bennick's case. And this is a thing. This is the thing that I think that regarding Indian context, community policing, for example, what happened in Tamil Nadu, that it went to a different stage that was not anticipated by people when it was started. I think that's a very Indian concept. I think when you get power, like when you get access to power, it tends to corrupt, or it tends to make you as someone who's above other people, which is exactly the problem of policing in India. The concept that in power you are above someone else, or you are having close nexus, like you are having access to power, that tends to, I think, leads to a lot of practices which goes contrary to the nature for which a scheme is started. Yes, Karnataka did a good job. Bangalore, it's been successful in a sense that the community, they have said they've been satisfied with the response. But in the Indian context, I think if community policing is starting, there needs to be a lot of study regarding the area in which a particular officer is posted. If it's a community, then since our cities are divided based on the communities, each area, like for example, let's say slums are divided. We have areas that are it's separated, like a zone is separated from the rest of the city. There are zones where there's only affluent class. There are zones where you find only poor class. So I think when we are talking about community policing, it's very important for the system to first study about the district, about its people for whom they are starting it. The officers who are posted, they needs to be given adequate training about the kinds of demand that the community wants. For example, if you talk about Jharkhand, it's a majorly tribal dominated society. They still have their own ways to deal with small issues that occur in their areas, for which we have panchayat systems. So I think in those places, or in places where we are talking about community policing, where major mistrust, where there's a major gap of trust with the police. So that's the whole idea of community policing, that you bridge the gap between the citizen and the police. So it's very hard for people who are coming from the marginalized community to trust someone who's coming and telling them that, okay, now we are going to work together. So I think when it comes to the Indian context, we need to learn as to how the Western countries have done, how US has done. US and UK has been having community policing before India. So we can learn from other nations, their failures, and then implement it with a local aspect and a local understanding and see the structure changes. The entire idea is the structure of the police changes from being catering to just one particular class and being offensive against the other. So that mutual bond, I think it's a good measure, but it needs to be implicated with precautions and learnings from Tamil Nadu and other countries. Yeah.
Right, sir. So in India, the general public believes that it is necessary for the police to use torture to extract confessions. This brutality is now considered to be an integral part of police invention, not just by the police, but also by the people. And thus, people ignore such awful confessions of the prisoners and use these statements like "kiya hai to bhuktenge." As we saw in the case of Hyderabad encounter, where the police encountered four human beings, and the next day, all they received was a police station. I agree, like that the crime they committed or they were accused of was disgusting, but the power to execute doesn't lie in the hands of the police. What are your views on this, and how can we tackle this problem?
See, torture as a means of investigation firstly shows the failure of police to deploy scientific investigation techniques, and it also shows its colonial approach to solving crime and dealing with people. It reflects on the department's denial to accept policing as a service to people rather than being an arm of the state to control the people and see people as subjects. It shows disregard to the rule of law and principles of fair investigation. And there are ample examples of terrorizing brutality of the police, where police has went beyond using torture as an investigation technique and have executed quote unquote mob justice despite taking an oath to serve the constitution. So the immunity of both using torture in investigation and in cases where police is allegedly murdered accused has shared roots in public perception of policing, how the general public sees the work of police. Police in India and as well as around the world is not isolated from the temptation of mob justice, and derogation from rule of law to seek vengeful justice is deep rooted in any human society. And police as a group is definitely not exception, despite their role as enforcers of the rule of law. So, and this vengeful justice seeking is fueled by the failure of criminal justice system to address crime, including lack of effective prosecution in many cases, which was also taken as a defense by the public defenders in the case that you mentioned. But I think for me, in my opinion, the solution lies in a right-based education and awareness, where attempts are made to establish faith in the rule of law, and it is ensured that the justice is seen to be done by the general public through effective prosecution and actually lowering crime rates, so that the public in general does not support this kind of behavior by police. The aspect, and the last point, and I think it's a very important point, is that the the aspect that derogation of rule of law to execute an accused, or basically to kill an accused, is not only a murder of the person who has been alleged of a particular crime, but it is also a disservice to the victim of the crime. It is a violation of the victim's right to justice by a legal prosecution and seeing a lawful punishment to the culprit. The other side of police encounters, I think, needs to be highlighted so that public cheering the heinous crimes by police can be stopped, and the victim side should also be put forth. I would say that the rights of the victim are also violated when a police encounter happens.
Yeah. Yeah, just in extension to what Siddharth has said, it's right. In India, the colonial hangover is there. The police that we have is more as a controlling power rather than as a prevention of crime power. So what we see in the police, so by going behind the reasons as to what are the possible reasons as to why the police uses these methods. Firstly, the lack of manpower. They are overworked, they are overstressed, there's a lack of infrastructure, there's a lack of adequate training. They have to do law and order and they have to do investigation side by side. So it leaves very little space for a person to do an effective investigation and a detailed investigation. it leaves them with little space, it leaves them with little patience to do a thorough investigation and to see exactly what happens. So they use the method that's a shortcut. In fact, there's an interesting story as to why in Evidence Act Section 25 is still there, because someone told James Fitzjames that this will ensure that a police does not rub chilies in the eyes of a person sitting in the shade rather than going outside and doing investigation. So he foresaw that in 1800s when he drafted the Indian Evidence Act, but we still see that confessions are a common thing that you'll find in any charge sheet, despite everyone knowing that the confession doesn't hold any ground in law. But that's their shortcut to go with a case. That's how they want to go with a case. The second thing that I think that they use this is because their stereotypical idea of who a criminal is and their way to take out their frustrations and their own idea of justice. As to what Siddharth rightly said, that this is not just a failure of one institution, it's a failure of the entire criminal justice system. The lack of faith amongst the public in the judiciary also goes with the police officers. They don't trust the judiciary. So they have their own idea of justice. They want to punish themselves. They don't, my experience tells me that they're not really concerned about a conviction, and which the even the stats say most of the cases they go in acquittal rather than conviction, because the police officers don't care about convictions. All they care about is the first 3-4 months of investigation, of torture, that they think satisfy their idea of justice is enough. You take up any case, small cases of theft, they charge them with Arms Act also, because they think that if they simply charge them with theft, they'll go out. Or in any case, let's say if a tribal or if a minority is caught, they'll charge them with UAPA, maybe. In state of Jharkhand, it's quite common to charge Adivasis who are protesting against their land acquisition, to charge them with UAPA, to give out a message and to take their own idea of justice. So I think when we talk about encounters, the another reason is the glorification of police encounters. There are movies made on them, and in fact, the Bollywood actors and in fact South Indian the directors, they've also come out after the Tamil Nadu case. They've regretted of glorifying police violence, because that also creates an impression in the mind. It supports them. So as long as the public is supporting this, the police will get an incentive to be the way they are. It's only a strong movement. Let's say, for example, what's happening in US. Like they've come to a stage where the entire public comes out against police atrocity. That does not happen in India. In India, a handful of cases go out, a handful of cases are protested. I think before this Tamil Nadu case, I don't remember what was the last case in 2020 where, with such a massive outrage, people came out. So that is also needed, so that the perspective changes amongst the police also, that okay, this is not acceptable in the society, along with strengthening the justice system, separating the law and order and investigation, giving them more time, as Siddharth rightly said, training them for scientific investigation, using more forensic science. So these are some things that can be employed and which can go in a long way in improving in changing this existing form of interrogation and investigation.
So, the next question is in reference with the custodial death of the father and son duo, Jayaraj and his son Bene, in Tamil Nadu. What the police did was absolutely wrong, but an article in Indian Express mentioned that according to an eyewitness, when the two were taken to the magistrate court, the magistrate waved his hand from the first floor of the building while the police was standing on the ground floor. The two were then sent on remand to Kovalpatti subsoil in the next few moments. So, do you think that the magistrate has the power to prevent such incidents from happening?
I would say that the first contact of the accused to the judicial side of the criminal justice system is the remand, or as it is called, the first production hearing. And it has immense importance in ensuring a fair trial and preventing these kind of things. But the practice of what can be called as a mechanical remand is rampant in India. And mechanical remand is not only during the first production, but even when the person has been sent to judicial custody. We hear a lot of cases where the prisoners are produced via video conferencing, and the judge is not even present. It is the reader of the judge who is just present and just records the mere things and extends the remand. without even hearing the side of the police or the side of the accused. And it is done to, actually, it is an act to evade the procedural safeguards of a proper remand hearing. In the Anish Kumar case, the Supreme Court had clearly stated that authorizing detention without recording the reasons in writing and ensuring that the procedural safeguards are were ensured by the police would be liable for departmental action by the High Court against the magistrate also, as I earlier also mentioned. And therefore, magistrate at the remand stage has enormous powers and responsibilities to safeguard the right of the accused, uh, uh, whether it be with regards to ensuring that the accused is not mistreated, accused has not been tortured, accused is not illegally handcuffed, or in the case of Afzal Guru, the Supreme Court very clearly stated that it is the duty of the magistrate to inform the accused of their right to legal aid and legal representation. However, there were other observations which do not go very well towards the rights of the accused, but this thing is well settled that the magistrate is the first person, is the first point of contact of the accused to the judicial side of the criminal justice system. And the magistrate has a paramount duty to ensure that the rights are not violated. So I think Shailesh can add more on this aspect.
Yeah, true. Magistrates are the first line in defense. They are the first. They're the first authority where any person is brought, and it's mandatory. It's something that's always followed. So, and the way that now the system has become is it's very mechanical. If you look at the accused, they rarely look at their scars. They rarely even ask them. Even if you have fresh marks, even if you have fresh fractured bones, if you have fresh plasters, still they don't ask. And that's something that we saw during the Northeast riot cases, where even despite an order of the magistrate, the police refused to provide us the medical reports. They refused to take them to medical treatment, which shows that even the police are aware that the magistrate is not going to do anything. It's basically a failure of the entire system. So probable reasons can be that since the magistrates are also working under so much pressure, they don't they are not left with the spine to do something that can be regarded as a bold act. Section 437, it clearly provides, even on the first, in fact, leave 437, in fact, on the first day of the production, the magistrate has a power to release an accused on bail. If he deems fit that he's no longer required in custody. Investigation can happen even if an accused is out. Investigation, it doesn't matter. So there are many, magistrate has immense power. There are huge judgments that gives magistrate this power that you do not have to exercise it mechanical way. But why do they still exercise it? It's because what, in my personal experience, I've seen is that because whenever a magistrate has tried to do something out of a conventional way, he or she immediately receives a show cause from the higher authority that as to why you did this. In fact, even a simple case of bail. Let's say a person is arrested and you move a bail application within 2 days of his arrest, the magistrate will be hesitant to give him bail. Same goes with the sessions court. Sessions court will not give you bail in serious offenses. They'll say that you go and take from the High Court. Magistrate says that you go and take it from the Sessions Court. Despite they've been very well knowing that, okay, this is the power and they can very well grant it. So there's a lot of politics also behind it. There's a lot of pressure. And so these things affect their independence, even if some magistrate wants to do a good job. And in the case of Jairaj Benix, we clearly saw as to how mechanical it was, and they could have been saved if magistrates simply saw them and followed the procedures. So I think it's a very important thing, and Supreme Court have time and again held that if magistrates and the sessions could perform their duty, rarely the case will go to the High Court or to the Supreme Court. They are majorly burdened with the cases of bail. The major amount of criminal matters before the High Court is bail. And those are the cases in which the lower courts can grant bail. So I think it's very important to, like, yes, it's an institutional reform. We cannot just reform police structure and leave the magistrates. It's an institutional reform. So these things magistrates need to be more independent, and there needs to be like strict implementation of these laws. Yeah.
Right. So, do you the political class and the representatives that we elect direct or indirect role to play in such incidents? If yes, then please let our audience know what role do they play.
Yes, I think yes, they do play a direct role because their acceptance Am I audible? I think your video froze or Siddharth's video froze. Can you hear me?
Yes, sir, I can.
Yeah, yeah. I think yeah, they play a direct and indirect role both, because the legislature, they speak what the public speaks. They have to speak what the public wants. They'll never say any statement that goes against what the public sentiment is. So when Yogi Adityanath says that okay, we are going to encounter people against tough crime, he's accepted. He plays a huge role. It motivates the police officers. Police officers know that if they go against a particular religion, a particular community, there's protection for them. There's protection from higher ups. So this thing is elected leaders, if they make a statement, it gives morale to other people to do certain action or not. And it's very common. Change of power in state influences how the criminal justice also works in that state. And we have seen in the state of UP. NSA being used for cow slaughters, increasing use of NSA, increasing cases of encounter because the change of political power is there. So yes, the elected representatives, they play a huge role. In fact, even if you compare it with other states, like for example, US, the war on drugs or going tough on crime, it's all legislature. It's all people convincing, legislature convincing you that, okay, these people are not safe for us. When we're talking about, in this case, who watch the watchman, and we're talking about the marginalized community, it becomes very important for the people who are in power to give out a message that, okay, even you are valued and you're not a second class citizen or you're not an assumed criminal. The thing that there's going to assume criminality against certain person, and then an assumption that certain sect of people are inherently criminals, is an idea that is propagated by our legislatures. So I think they play a very important role in how the criminal justice system works in a state, and they should be more responsible.
And I think it is a very complicated point, because political will is definitely a major catalyst that can work towards reforming the police institution or the prison institution. But it is also, the primary reason why there are not reforms. In a situation where a majority of elected representatives in India have criminal cases filed against them, or trials going on, it is imperative that they have a vested interest in keeping the police corrupt and mired in the political tussles. And I was just looking at the National Police Commission report, which was submitted in 1979 to the central government, and it was kept pending till 1996. And it was kept in cold storage because the government did not want to implement it. And the government is formed by the political persons. So, but I still believe that there is, there, if there is a political will, it can work as a catalyst to see reforms in the policing. But at the same time, I would also say that reform seekers should not rely much on the political will. And police reforms can be very well led by judiciary and organizations that seek accountability and structural changes, because demanding accountability and structural changes will definitely bring changes in the legislation which are required. But expecting a lot to change from the political will from the top to bottom, I think is difficult in terms of policing.
Yeah.
Thank you, sir. Also, a report published by National Campaign Against Torture in 2019 revealed that 60% of the people that died in police custody belonged to marginalized communities. Like, can this be something intentional? Like, are our authorities still stuck on the notions of casteism and treat the minorities and marginalized communities in an inhumane manner?
Yeah.
See, Bob, as I've already emphasized, that police system is not immune to the social evils that have cleansed the evolution of our society to be more humane and truly modern in that sense. And even if a movement, even if you forget how casteism and discrimination runs in the veins of police and other authorities, as Shailesh had mentioned, there has been a research which found that in Rajasthan and UP, there existed laws. And in Rajasthan, I think recently the manual has been passed. Otherwise, in UP, it is still existing, where caste is mentioned in the laws. And in UP, the prison rules contain, quote unquote, the words that respecting caste prejudices is a part of the reformation process. In Rajasthan, as Shailesh mentioned, that it was part of the on the basis on which labor in prison was divided. So it is not just a notion, but it is very well present in some of our archaic laws also. One thing I would want to highlight is that as far as the data on disproportionate representation of marginalized communities among the persons who died in police custody is concerned, it is important to read this data with a disclaimer that around 70% of prisoners in India belong to marginalized caste, which could be SC, or the scheduled caste, scheduled tribes, or the other backward caste. So, assuming that if there are 70% prisoners belonging to marginalized caste, there would be similar number in the arrests also. But what is important is to understand here is the role of intersectionality. So marginality need not always be of caste. It could be anything, as we all understand, it could be anything from gender to economic status to caste to nationality, religion, or a different or a disability or anything in that case. And in most of the cases where there is a case of persecution or torture by the authorities, it is a mix of many marginalized identities that play a role. I think more investigative research is required to understand why marginal identity of the individual, which marginalized identity of the individual makes them more prone to torture in custody. One example could be that how many of the persons who died in custody had effective access to lawyers while in custody. So there can be many, intersectional marginal identities which play a role. Yeah.
Yeah. Yeah, just an extension. So, yes, true. Our criminal justice system is institutionally caste bias. It's designed in a way that's made to perpetuate a cycle of poverty, crime, and casteism. It's just a concurrent cycle. For example, the Criminal Tribes Act that was passed during the colonial time, it criminalized a particular sect of people, saying that these people are criminals.
Mm.
After independence, though we repealed the act, we brought a habitual offender act, which gives power to the police to have a constant surveillance over a certain group of people who are an habitual offender. Now, how does a person becomes an habitual offender? Police picks you in a case, police picks you in another case, you are a habitual offender. Why does police pick one particular community more? Because it's still the notion that this particular community is inherently criminal. So, in fact, the entire criminal justice system is working in that way. The police think that this particular community is criminal. The judge who's sitting on the bench, he thinks that a particular person is criminal. And our legal aid, as Siddharth said, it's already in shambles. Lawyers are overworked, underpaid, they have little incentive to stand for you. So the entire criminal justice system is designed in a way that it makes sure that the casteism exists and people who were lower caste are kept in that form. For example, a really nice research done by Criminal Accountability Project based out of Bhopal, they made a really nice research and they said that in fact, the consequences of the Criminal Tribes Act, as it continued after post-independence, the people who are charged with a crime, they have to travel to far distance to attend court hearings, they have to pay to the lawyers. What they lose in all of this is they lose their income, they lose a fixed mode of employment, they lose families. So it just keeps a cycle going on. So, and plus the other thing is the diversity in the police force. That's also an issue. That the police force is inherent, that the diversity is also a matter of concern, that we need to increase diversity in police force. But that also I don't think will change a lot, considering the rules of the games are set. So no matter if a minority comes into the in a police role, he has to play by the rules. So the system is designed in a way. So if we are talking about casteism in the police system, it's again an institutional reforms. Studies needs to be done as to how this system is perpetuating. And under trial prisoners, 70% of the under trial prisoners belonging to the minority, most of under trial are belonging to the minority group is not a coincidence. Most of the people dying in custody is not an incident. It's not a coincidence. It's the thought that a person can get away, and it's the social economic background of the person also. They're coming from a poor background. They don't know their legal rights. They don't have the strength to fight a legal case. So all of these things goes a lot. It's all a combined effort. If we're talking about casteism, and if we talk about reforms, we have to study everything. Just making laws more strict is just a piecemeal effort, and a more thorough research is required if we need to bring structural reforms in the system.
Okay. So the basic idea behind putting criminals in a prison is to reform them so that when they step out, they are a better and they know the difference between right and wrong. But this notion today has lost its meaning completely. And the current situation of our prison is really poor. It's overcrowded and hardly any facilities provided. In such a condition, is it even possible to expect a person to change in a positive manner?
So I'll mention here this case. So in the case of injury in human conditions in 1382 prisons, I'm just about to quote a famous line from that case. The then Justice Madan Lokur had observed, and I quote, "What is practiced in our prisons is the theory of retribution and deterrence, and the ground situation emphasizes this, while our criminal justice system believes in reformation and rehabilitation." So the court itself has also emphasized that merely changing the nomenclature from prisons to correctional homes will not solve the problem. More than two-thirds of prisoners in India are yet to be convicted of a crime, as Shailesh mentioned, and most of them are under trials. The responsibility of the prison authorities in this case is not to reform them as they are yet to be found guilty of any crime. But the primary responsibility of the prison authorities for two-thirds of their wards is to provide them safety and ensure that they are able to participate in their trials. And the and answer to why reformation and rehabilitation of prisoners is not a reality is reflected in some statistics. I'll just tell you that, as you have already said, that there is rampant overcrowding in the prisons. Another point which needs to be seen is that on an average, rupees one, just rupee one, is spent on per prisoner per day in India on vocational, educational, or welfare activities, and the expense of clothing is included in this. So, what if we see the prison expenditure on what the prisons are, spending their money? They're spending less than 1 rupee on the reformation activities, which could be vocational training, educational programs, or any other welfare activities. Another thing which is very interesting to see is that there is a concept of correctional staff in prisons, which includes psychologists, welfare officers, or correctional officers, depending from state to state. If we see an overall national data, there is one correctional staff in prisons for 756 prisoners. So, what do you expect from one correctional staff for 756 prisoners? And this is an average data. I'm sure from around 10 to 18 states, there is not even a correctional staff present in any of their prisons. So they are either hiring, so they are not hiring correctional staff. They are just using activities like yoga and such. But there is no plan, and there is no human resource to execute that plan. These are individual activities. There would be a yoga activity for 2 years. The yoga is limited to yoga. It can give you physical fitness. To some extent, it can give you mental health benefits. But it is not a reformation plan which a correctional system, which calls itself a correctional service, should have in place. Moreover, there is an overall staff vacancy of 30%. So the situation of prisons is no less than a plague in itself. And then, you are very correct. In such a situation, it is not practical to expect that the prisoners will be reformed or the convicts will be reformed. And rehabilitation is something way far away, because rehabilitation is also important. If you have reformed the person after keeping the person for more than 10 years in the prison, uh, more than 50% of convicts in India are life sentence prisoners. So you have lakhs of people in prison who will be spending their life, which means 14 years, 20 years, or in some cases, natural life. But a lot of persons will get out after 15 years. Suppose even if they are reformed, even if in reality they are reformed, there is no rehabilitation system in place. What will they do once they get out? So reformation can never be complete without rehabilitation, and both these things are very far away, at least for the Indian prison system, because of the administrative issues and the administrative neglect that the prison system is facing. There are individual, isolated examples where but these are also led by individual prison superintendents only, who get transferred, and there is no such system in place, basically. Yeah.
Yeah. Yeah, to extend Siddharth's point, yes, the prisons are overcrowded and it's a huge, and the shortage of prison staff, shortage of infrastructure, overcrowding, these all are the reasons as to why there cannot be a very effective plan to rehabilitate prisoners. Some prisons have started, for example, Tihar jail started their own factory making biscuits and other products where prisoners are employed and they're given some amount of money as a remuneration once they go out of the prisons. So these things have been employed, but talking about an overall structure as to how the prisons function in our country is a really bad state. The prisoners are not put with an idea that they'll come out as a better person. The prisoners are put at the first place to teach them a lesson. So once your idea is to teach someone a lesson, you can never implement certain reforms that certain measures that are going to benefit the person. Your idea is to come in. So we have to change those things. There has to be measures. For example, yes, vocational courses should be there. Considering most of the people come from a minority background, they don't have the necessary skills. They majorly rely on their traditional occupation, be it farming, be it tanning, be it leather industry. So there has to be training mechanism because once you are involved with the criminal justice system, you are more likely to be spend a lot of considerable time. So they lose their employment. Once you lose unemployment, you go back, you don't have a adequate means to sustain your livelihood. So there's a tendency to go back again to the same place. So this is a continuous cycle that goes on, and prisons are a huge reason that it's still going on. So I think when we talk about reformation, when we talk about punitive or rehabilitation, again there has to be structural reforms, and everything can just having things on paper. For example, yes, prison might have on paper that you need to go for a vocational program, but if you don't have anyone to give you a vocational program, it goes out of the window. Yes, you have psychologists, you have a provision of psychologists in prison, but you don't have anyone to counsel the prisoners. The entire program goes out of the window. So when we talk about prison, there has to be reforms also in the terms of like changing certain laws that doesn't need a mandatory prison sentence, taking out the discretion from the judges of releasing someone on jail and making it mandatory to release on jail. 167 is a good provision. It helped people who are not charge sheet is not filed, they come out in 90 days. But again, police found a way, they file an incomplete charge sheet and you're still stuck. So there are a lot of things that needs to be addressed when we talk about overcrowding of prisons and rehabilitation. When we talk about convicts, then there has to be a holistic defense model as to you plan out, you seek for an employer. People don't want to employ someone who has a criminal background. So you need to look for prospective employers. A person who's convicted cannot get a government job. If charge sheet is filed in cases, you cannot apply for government jobs. So these are the things that become a huge barrier for a person. For example, let's say a 21 years age person, he is involved in a crime. He still has his whole life left to learn and to grow. But when you put these restrictions on persons to not apply for government job, not getting employment in places where they need a clean record. So these are the things that needs to be looked at, and that's how we can go with the reforms. Yeah.
So the last question is that more than 100 years have gone by since Birsa Munda died under mysterious circumstances in jail. India has successfully celebrated 73 years of independence, but it still has a long way to go. Citizens of this world's largest democracy fail to understand and appreciate the rights of the prisoners and accused. Not only this, our government failed to pass pending bills like Prevention of Torture Bill. What reforms would you suggest, and on what scale do you think their implementation is needed?
So, I mean, yeah, so I think that yes, passing new laws is required, but I think more than passing new laws, first a structural understanding of the institutions has to be done. Understanding how the police institution works, understanding how the judiciary works, understanding how the legal aid lawyer works, and how the prosecution works. So I think an overall understanding and overall reform in each of the institution is needed at present. For example, let's say things like, yes, we need a specific law for police brutality. For example, in the present case, even if you have cases where a police officer is slapping or beating with sticks, you can at best charge him with causing simple hurt if there's no fracture or if it does not satisfy the conditions of a grievous hurt. So a simple hurt is bailable offense. Hardly anything will harm. happen to the police officer. So yes, we also need strong laws which specifically define what a police torture is, which defines custodial death. We have section 176 1A, which demands an mandatory magisterial inquiry, but reports say that if there are 255 cases of police custodial death, around 55 or 100 cases are there where magisterial inquiry has been conducted. So, along with having a laws, we need a strict implementation and a mechanism where we can implement these laws. For example, right now you cannot, even if you file a case, there are legal barriers taking sanction against the public officers. So these things needs to be removed. Then, of course, talking about who will watch the watchman, where you'll file a case against a police officer in the same jurisdiction in the same police station. Very few cases go to the High Court demanding an independent inquiry, and half of those cases result in an effective order for an independent inquiry. But even when we talk about an independent inquiry, who are the CBI officials? Who are CID people? They are the same police force. There's no one recruited from outside police force in these agencies. They're majorly police force only. You can have some people from paramilitary force, but it doesn't change the structural context of these independent agencies also. So these reform making it more stricter implementation, including public, then other things like diversity can be one of the measures, but yes, diversity doesn't work when the structure is as such in which a person cannot make innovative choices. So you have to abide by this. Then making changes in the laws like Evidence Act and reforming magisterial powers of granting bail, making mandatory bail in most of the like petty crimes, because we have seen the if minorities are picked for crimes, they die in custodial death. Most of them are petty crimes like theft, cow slaughter, and these are the offenses for which they are dying in police custody. So we can have an overall mechanism where we look the past and the present and we see how the Indian society works. What are the cultural contexts? What are the caste contexts? What are the socio-economic background of the force, the citizen? And considering all of that, we need reforms. And these reforms to expect from the legislature is a very far sight. They can order for an inquiry. We have numerous law commission reports that are tremendous, that are fantastic, but hardly implemented. We have laws for malicious prosecution where you can prosecute a police officer, but it's hardly implemented. So I think if we want a reform, we need a movement. We need a movement like what's happening in US, because only those things can force people to have law. And even when we are forcing people to have law, we cannot have piecemeal legislation. Like let's say Nirbhaya rape happened, we forced them to change laws. What they did was that they made laws more strict. Barely changes the rape crimes in India. So we don't need, when we are also protesting, when we are demanding a civil action, then we need structural changes. And it can only happen with a mass movement. Because in India, we see around there's very little discussion that goes around criminal justice system. Even in our houses, we think that, okay, it's absolutely fine to cut genitals of a rapist and it's absolutely fine to cut hands of a thief because they think that it worked in Saudi Arabia. That's their analogy. So we need to change the entire thought process that, okay, this is not how the criminal justice system works. We can have reforms like open prisons. Open prison in Jharkhand, there are only 37 inmates compared to 100 was the official capacity. So we need to utilize more of these things. It needs to be a mass movement, mass awareness, mass education. Only then we can expect a tangible reform, because ultimately people from our society are only going to be there who are going to execute it. So we need to make sure that people who are going to execute it know what they are going to execute and know what they're entering into. So I think my take on the criminal justice reforms.
Yeah, and I think adding on to what Shailesh said, even I just looking at this, even in the oversight watchdog, the National Human Rights Commission, the investigative teams are formed by people who come from the police cadre from various states. So in the Hyderabad case, the team that went to investigate the alleged violation of human rights and the alleged fake police encounter, the team involved people who were very recently part of the active police force in Uttar Pradesh. So the system is structured in a way where the rights are there on the paper, but the procedure and the means to achieve an effective remedy when the rights are violated is such that it becomes just an eyewash, and nothing comes out of it. There are oversight bodies like NHRC for one, and there is a concept of police complaints authorities where public can file complaints against the police, but mostly these are non-functional. In case of prisons, there is a body called Board of Visitors, but these are not very much functional. There is a body called Under Trial Review Committees, which has to ensure that no person is in prison unnecessarily and there is no prolonged detention. These under trial review committee, as an exception, is working, but is not working in the manner it is designed to. And I think I'll just conclude by this very interesting, I think, an important slogan that I found by Birsa Munda on internet. So, and please forgive me for the ignorance of the pronunciation here. It says Raj Setav Jana Maharani Raj Tundu, which according to the internet means that let the kingdom of the queen be ended and our kingdom will be established. But even after the queen rule has ended more than 75 years ago, the legacy of the colonization and the colonial governing, the colonial handling of people by the rulers is still very much fresh in the police and prison system of India. And unless this is changed, a structural change is brought into how the police and prisons function in India, the reformation will not be complete.
Thank you so much for your insightful responses. Our viewers will have many takeaways from this session, and it was my honor to host this session. Thank you so much.
Thank you so much for having us.
Yeah.